हेलो, नमस्कार सर। नमस्कार मैडम।
हेलो।
हाँ मैडम, नमस्कार मैडम।
नमस्कार मैम।
सौरभ, कैन यू हियर?
नमस्कार
हाँ जी,
मैम।
आपकी आवाज, यू आर
नमस्कार जी।
ऑडिबल मैडम, वी कैन
हाँ
हियर
जी,
यू।
हाँ जी।
यस।
हमारे गेस्ट हैव जॉइंड और नॉट?
हाँ, गेस्ट हैव जॉइंड।
ओके।
गुड आफ्टरनून मैम।
गुड आफ्टरनून नितेश, कैसे हो?
ऑल फाइन मैम, एवरीथिंग।
अश्विनी, गुड आफ्टरनून।
Good afternoon, ma'am. So sorry, I was waiting for my turn to come. But you are quicker than me.
नमस्कार प्रमोद, कैसे हो?
मैम बढ़िया बढ़िया।
नमस्कार प्रोफेसर शर्मा सर।
हाँ, बहुत बहुत शुभकामनाएं आपको। नमस्कार।
सौरभ, अरुण जी ने ज्वाइन कर लिया क्या?
हाँ मैडम, ज्वाइन कर लिया उन्होंने।
अच्छा, दिख नहीं
4
रहा।
बजे आगे बैठ जाएंगे। अभी वो जो है उनके सेक्रेटरी साहब ने जो है ज्वाइन करवा दिया।
ठीक है, ठीक है, कोई बात
जी
नहीं।
जी, यस।
और वो कहाँ है, जतिन? जतिन ने कर लिया ज्वाइन?
हाँ जी, जतिन ने भी कर लिया। जतिन हैज ऑल्सो ज्वाइंड। महावीर सर हैज ऑल्सो ज्वाइंड, आई सपोज। महावीर सर, नमस्कार। महावीर सर तो ढूंढ रहे थे।
अब भी शायद नहीं
सर है, सर यहीं पे नहीं यहीं है, दिखाई दे रहे हैं।
अच्छा।
महावीर सर नमस्ते।
इंचार्ज साहब नमस्कार।
वो बिजी होंगे अभी थोड़ा सा। मैंने उन्हें कहा था, मैंने कहा सर ज्वाइन कर लेना थोड़ा पहले, और जो है 4 बजे फिर स्टार्ट कर देंगे, तो उन्होंने ज्वाइन कर लिया।
ठीक है, ठीक है।
जी।
हेलो अंजय।
गुड इवनिंग मैम।
गुड इवनिंग, कैसे हो?
ठीक है मैम, आप कैसे हैं?
हम तो ठीक है। आपका लग रहा है हिमाचल में बैठे हो।
नहीं मैम, दिल्ली में ही है।
नमस्कार महावीर सिंह जी।
नमस्कार सर। नमस्कार जस्टिस सर।
जस्टिस
Good
सर,
afternoon to everybody.
गुड आफ्टरनून सर।
गुड
नमस्कार।
आफ्टरनून अरुण जी।
Distinguished speakers, senior professors, my dear colleagues, and my dear students present here. On behalf of Law Center 2, I extend a warm welcome to all present here. Coming to the topic of the seminar today, with lots of development on the front of socio-economic offences, it is an opportune time to discuss the doctrine of mens rea as applicable or not applicable, we will see, to such offences. Actus non facit reum nisi mens rea has been a cardinal principle of criminal law. But we are now witnessing some deviation in this respect, especially post-liberalization and particularly in the ambit of socio-economic offences. This seminar attempts to brush upon a spectrum of such interesting aspects of what I would call modern world offenses. I convey my heartfelt gratitude to Justice A.K. Tyagi ji, Honorable Judge, Punjab and Haryana High Court, Professor Dr. R.N. Sharma ji, Dean and Director, School of Law, IMS Unison University, Dehradun, and Shri Jatin Kalon, distinguished research scholar and our colleague, very dear colleague, Faculty of Law, University of Delhi, for accepting our invitation to speak on this topic today. I express my sincere gratitude sir, am I audible now? Hello.
Yes, sir, you're
Yes,
audible.
sir, you are audible. You are audible.
I apologize because some connection glitch was there. I express my sincere gratitude to Professor Dr. Mahavir Singh ji, Professor in charge, Law Center 2, Faculty of Law, University of Delhi, for mentoring us and to become a pillar of strength for us in organizing this seminar in such a short span of time. Our heartfelt gratitude to Professor Dr. Kiran Gupta ji, Director, Seminar Committee, Law Center 2, for believing in us and supporting us throughout. In our Indian tradition, when we start a pious thing, we remember God. What can be more reverent than spreading light of knowledge by holding such seminars? And what can be more befitting to such occasion than rendering Saraswati Vandana? I would call upon Ms. Priyanka, a first-year student of Law Center 2, to recite Saraswati Vandana. Priyanka.
Good afternoon, everyone.
Good afternoon.
I am going to present Saraswati Bandana. Jayati Jaya Jaya Ma Saraswati Jayati Veenavadini Jayati Jaya Jaya Ma Saraswati Jayati Veenavadini Jayati Jaya Jaya Ma Saraswati Jayati Padmasane Mata Jayati Shubhavardhayani Jayati Padmasane Mata शुभ वरदायिनी, जगत का कल्याण कर माँ, जगत का कल्याण कर माँ, तुम हो विघ्न विनाशिनी। जयति जय जय माँ सरस्वती, जयति वीणा वादिनी, जयति जय जय माँ सरस्वती। कमल आसन छोड़ दी माता, देखे दुनिया की दुर्दशा। कमल आसन छोड़ दी माता, देखे दुनिया की दुर्दशा। शांति की सरिता बहा दे, शांति की सरिता बहा दे, फिर से जग में ज्ञान दे। जयति जय जय माँ सरस्वती, जयति वीणा वादिनी, जयति जय जय माँ सरस्वती, जयति वीणा वादिनी, जयति जय जय माँ सरस्वती। थैंक यू।
बहुत बहुत धन्यवाद प्रियंका जी। Now I would call upon the professor in charge, Law Center 2, our beloved Professor Dr. Mahavir Singh ji, to welcome our guests today and formally declare open this seminar. Professor Dr. Mahavir Singh ji.
Yes, Saurabh, am I audible?
Yes, sir, you are audible, sir.
Yes, sir.
Yes, sir. Okay, thank you, Saurabh. So, welcome all of you, and I would like to apprise a few words about our center. First of all, this Law Center 2 is the premier institution of learning of law in the Faculty of Law, University of Delhi. It was established in 1971 in a rented building of ARC College, Dholakua. Since 1971, it has taken a big steps in imparting quality of legal education to thousands of students all over the country. The center is going to complete
Can I play this?
of its establishment in few months to come. Law Center 2 will be celebrating its golden jubilee in July 2021. Now, first of all, on behalf of Law Center 2, I first welcome our chief guest, Justice A.K. Tyagi ji, Judge, Punjab and Haryana High Court. Since Justice A.K. Tyagi ji does not like himself to be called as my lord, so I may seek his permission to address him as a judge only.
Yes, please.
Justice A.K. Tyagi ji completed his BA, did his BA honors from Deshbandhu College, Kalkaji, and thereafter completed his LLB from this Faculty of Law, University of Delhi. A multifaceted personality, sir is often referred to as a conscience keeper of justice and the constitution in the courts, moving up the ladder from judge in the junior division to an honorable judge of Punjab and Haryana High Court. You are an inspiration for our students who have recently joined the bench. We hope and believe that in years to come, you will keep on dispensing justice through your inimitable qualities of justice. So, sir, I welcome on the behalf of
सर मैं कह रही थी जब तक इसका फाइनल होगा तो हमें काम शुरू करना टेम्परेटली
uh, coming here and we are totally delighting.
के ऊपर ये जो 4 या
next-
5 में से एक न्यूज़ है
The next, our guest of honor,
तो फिर के वहाँ पे हमें बुलेटिन वगैरह का काम करवाना चाहिए
Pinky ma'am, may you please mute yourself? Pinky ma'am, may you please mute yourself?
please, madam.
I'm calling her separately, sir. You please pause for a moment. I am giving her a phone call. Sorry for the inconvenience to the audience.
Okay. Now, on behalf of Los Angeles 2,
अब
I now welcome Madam, please mute your. On behalf of LCQ, I now welcome Professor Dr. R.N. Sharma, Dean and Director, IMS Unison University. Professor Dr. R.N. Sharma completed his law from Department of Law, Jayanaran Vyas University. So he then served as a Dean and Head of Law Department of Jayanaran Vyas University, Jodhpur, and remained as a Vice Chancellor at IASE Deemed University, Sardar Saheb. He has completed 35 years. He has 35 years of teaching experience, in which he authored more than 9 books and more than 45 research papers in various national and international journals. As a lighthouse of legal education, we are sure that Professor R.N. Sharma will keep on spreading the light of legal education and legal awareness. Another speaker today with us is Mr. Jatin Kalon. He completed his LLB from Law Center 1, Law Faculty, University of Delhi, and LLM from Indian Law Institute, New Delhi, and now he's a research scholar with this faculty of Law, University of Delhi, and also teaching at Law Center 1 as guest faculty. In legal circles, he is known as serious student with a keen interest in criminal law. So I welcome all of our guests, chief guest of honor, and our student Jatin Kalon. And now I request Saurabh Rana to go ahead.
Thank you, sir. Thank you, Professor Dr. Mahavir Singh ji, Professor at Law Center 2. Now, I call upon our first speaker today to share his views on the topic. Approximately 30 minutes have been allotted to each speaker, and then we throw open the floor for students to ask a few questions for around 5 minutes. So now I request Jatin Kalon to share his views on the topic today. Jatin.
Honorable Justice A.K. Tyagi ji, Judge, Punjab and Haryana High Court, Professor Dr. R.N. Sharma ji, Dean School of Law, IMS Unison University, Professor Dr. Mahavir Singh, Professor in Charge, Law Center 2, Professor Dr. Kiran Gupta, Director, Seminar Community, Coordinator Saurabh Rana sir ji, my teacher, my mentor, faculty member of LC2, and organizing faculty members, my students, and all the general persons. Today we are here to discuss about the aspect of mens rea in socio-economic offences. To begin with, I would like to talk about a little bit about the history of the concept of socio-economic offenses. Now, keeping apart the legal fiction, usually in the historical times, there was a crime committed towards individuals. And as I said, keeping apart the legal fiction, the injury caused was toward the individual person. But with the advent of technology, with the advent of science, we saw that there was a huge impact, a huge injury, not just to one person, but at the public, but to the public at large. We saw that American criminologists like E.H. Sutherland talking about socio-economic offenses in the language of white-collar crimes. And we saw another sociologist known as Mr. Edward Sattelberg talking about how white-collar crimes are pretty much different to certain offender-based crimes. And we then witness various, after post-independence, various law commission reports. We talk about various committee reports about how there was a rise in socio-economic offenses and how ultimately there lies a very thin line between white-collar crimes and socio-economic offenses. Now, when we talk about socio-economic offenses, the fundamental principles of criminal law undergo a very rudimental change, which basically is the topic of today's discussion. And I'd like to talk about this fundamental change with the help of the case, very famous case, the landmark case of State of Maharashtra versus M.H. George. So I would like to talk a little bit about the case first, and Saurabh Rana sir, with your permission, I'd like to share my screen so that I can
Yes,
talk a little
Jatin.
bit about
Yes,
the
please.
facts.
Please.
Thank you so much, sir. Sir, I hope my screen is visible to all of you.
Yes, it is visible. Jatin, go ahead.
Thank you so much, sir. So, as I said that, first very briefly, let's talk about State of Maharashtra versus Mayor Hans George case. It's a case of 1965, and I'll quickly surf through the facts of this case, wherein there was the main bone of contention was Section 8 of the Foreign Exchange Regulation Act 1947, in which the Parliament said that the central government or Government of India, it can by notification, except with the general special permission of the Reserve Bank of India, allow the bringing of gold inside the territory of India. With this section number 8 and the power deriving from the section number 8, we have Government of India issuing a notification on August number 25, 1948, which said that gold articles, among others, should not be brought into India or sent to India except with the general or special permission of the Reserve Bank of India. Now, on the same date, we have Reserve Bank of India taking action and issuing a notification which gave general permission for bringing or sending any such gold, provided it was through the transit to a place outside India. Now, after almost 14 years, we have Reserve Bank of India issuing another notification in the supersession of the earlier notification. And they issued this notification on November 8, 1962. And with this notification, the Reserve Bank of India said that there will be bringing of gold to a place outside the territory of India, and there will be further restrictions. But if there is a manifestation of that gold which is brought inside the territory of India while it is in transit, it has to be manifested in the same bottom cargo and transshipment cargo. And very importantly, lastly, on November 24, in the same month that there was an issuance of notification, in the same month on November 24th, the Reserve Bank of India published this notification in the Gazette of India. Moving on, we have now respondent M.H. George, who left Zurich by a Swiss aeroplane on November 27, 1962. Now, as you can, as all of you can deduce a little bit that the facts of this case, the main contention of this case, the action initiated by the respondent was almost 3 days after the provision was published in the Gazette of India. We have the respondent leaving Zurich and touching down the Indian territory on the very next day on November 28th. And we have custom officers of the Indian government apprehending the respondent. And after searching the respondent, it was found that there were 28 compartments in his jacket. And out of those 28 compartments, in 19 of them, there was gold slabs, which were weighing 34 kilos. And there was also a very important observation that the flight or this passenger was in fact in transit, that he was not destined for Indian territory. He was not destined to be here in our country. He was in transit and he was destined for Manila, Philippines. The Presidency Magistrate Court, they held the accused guilty under 2 charges, which was Section 8 of the Foreign Exchange Regulation Act and the Sea Customs Act. And the respondent was sentenced to rigorous imprisonment for 1 year, to which the respondent appealed, and to appeal in the High Court of Bombay, and the High Court held that the second proviso to the relevant notification issued by the central government, it did not apply to the person carrying gold with him on his body. So basically, there was a wordplay at execution, and we see that the gold carrying on the body was taken to be very much different to what the gold was carrying on the cargo. And court further held that even if the second proviso was applied, there was no mens rea that was necessary of the ingredient of the offense, and the respondent who brought gold into India for transit to Manila did not know that during the crucial period such a condition had been imposed. So according to the Honorable High Court of Bombay, the respondent could not have known about the condition, the issuance of notification by the Reserve Bank of India. Now let's talk about the composition of the Honorable Supreme Court in the current case. We have Honorable Justice Iyengar writing for Justice Mudholkar and Justice Iyengar himself. And we have Justice Subba Rao delivering a dissenting opinion. Both of the opinions in this case talk about 2 very distinct but very important ideologies, which we will be taking up in just a moment. Now let's look at the main 2 contentions taken up by this respondent, M.H. George. The first contention taken up by the respondent was that since in common law practice, the mens rea is an essential ingredient when we specifically talk about criminal law. And as we can see, according to the respondent, that there was no mens rea because the respondent left on 27th of November. According to the respondent's side, he could not have known about the date on which the law was changed. So basically, he was saying there was no mental condition, the state of mind, which could have implicated him. Second main contention taken up by the respondent was that the notification, which was issued on the November 8th, it was merely a subordinate delegated legislation. And it could not have been deemed to be in force from the date of its issuance or publication in the Gazette, but only when it was brought to the notice of persons who would be affected by it. So basically, the respondent here is saying that it does not really matter when the issuance or the publication in the Gazette of India of any law for that matter, it does not really matter when that publication was served. It really matters when it is actually brought into the notice of the persons who would be affected by it. And lastly, he raised a very subsidiary point that the notification of the RBI could not be attracted because the second proviso applied to the cases of cargo and not when the gold was carried on the person of the passenger. That we just now discussed, that the respondent claimed that the gold was carried on himself. He was carrying the gold on his body and not on any cargo. Now let's talk about the majority opinion authored by Honorable Justice Iyengar. Justice Iyengar, from the very initial moment, emphasizes on the fact that we need to address the language of the relevant provisions. So I want to, with this very platform, to my students, I want to emphasize on this fact that this case has been the first gateway of, for first year LLB students into the realm of criminal law. This is the first case that we read. And in the very first case, we have very, very important observations in this case regarding the focus on the language of the provision. So Justice Iyengar, from the very beginning, makes very sure that we have to stick to the language of the law. Justice Iyengar continues that in the present context, one reaches the conclusion that there is no scope for the invocation of the rule of mens rea. So Justice Iyengar is of the opinion that there shouldn't be any rule of mens rea after the perusal of the language used by the court. According to Justice Iyengar, the language itself puts an absolute embargo upon the persons who have not manifested the gold that they plan to bring to the territory of India. So if they have not manifested it, the language clearly manifests, the language clearly reflects the situation that there will be an absolute embargo put on such kind of people who do not manifest their belongings. Moving on, Justice Iyengar says that we need to focus on the language which says about bringing of the gold into the territory of India. We say that we have to observe here that the court is also taking into account about all the prospective luckless victims that Justice Subbarao will be talking about very importantly. So the Justice Iyengar is very, very wary of the fact that he's making a very important point by looking at the language that only the bringing of the gold will be penalized, and if without the knowledge, if it has been very mischievously put on the body, then the provision of the law clearly will not be attracted. But now Justice Iyengar is talking about the conscious act of bringing, that it doesn't matter that if you're bringing the gold with an intention of just bringing it, and it was very importantly observed by Justice Iyengar that the conscious act has to be there of bringing. Doesn't really matter what the purpose is. If you are bringing it inside the territory of law, it will be penalized. Then Justice Iyengar continues with the fact that there is no scope of invocation of the rule that besides the mere act of voluntary bringing gold into the India, it requires any further mental condition. Now, Justice Iyengar talks about the case of R versus Tolson, which was a very important observation, and there being a mind always at fault, which this present case talks about. Subject matter of a statute may be such that an act can be made criminal even when there hasn't been any intention. Now we are entering the realm of the mens rea vis-a-vis the socio-economic offenses. Justice Iyengar tries to make us understand that there are exceptions when it comes to mens rea in criminal law. That having no mens rea inside a provision, it is not an inflexible rule. There can be exceptions to it. Justice Iyengar tries to focus on the object of the statute, which is in the question in front of the Honorable Court. Justice Iyengar says that the Act, the Foreign Exchange Regulation Act, it is basically designed to safeguard and conserve the foreign exchange, which is very much pertinent to the socio-economic life of our developing country. This, according to Justice Iyengar, will be the reason that the respondent ought to be penalized, because the provisions need to be very much stringent, because we are talking about the economic life of our country. That we are talking about a grave social evil which is known as smuggling, and we need to eliminate it. Citing a very important case of Indochina steam navigation versus Jasjeet Singh, the court observes that we have to put an end to the illegal smuggling because it directly affects with the national economy of our country. And further, in the Indochina versus Jasjeet Singh case, it was observed that we have to look at the structure of the people who are involved in such kind of illegal activity. We have to understand that the physical part of smuggling, by one means or the other, are generally no more than agents. The people who are doing this, they are no more than agents, and presumably behind them stands a well-knit organization. That there is a huge network which felicitate this kind of illegal activity. It was finally held by the majority bench that the object and purpose of the act, in its effectiveness, it should be an instrument for the prevention of smuggling, which would be entirely frustrated if a condition were to be read into the said provisions. So we see that Justice Iyengar, authoring for the majority bench, is focusing on the language of the law and the very purpose and object for which the law needs to serve. Now we come to another important aspect of this case, which is the opinion of Justice K. Subba Rao. Justice Subba Rao, from the very beginning, agrees with the fact that there can be exceptions. There can be exceptions regarding the rule of mens rea in criminal law. He agrees with the fact, but he puts a caveat. He brings up a very important observation. He talks about the fact that the court should not read the doctrine of mens rea into the language of the statute. Justice Subba Rao observes that it is of the utmost importance for the protection of the liberty of the subject that a court should always bear in mind that unless a statute, either clearly or by necessary implication, rules out mens rea as a constituent part of a crime, the court should not find a man guilty of an offense, which was also observed in the Brent versus Wood case, an English case. So Justice Subba Rao is very much aware of the fact that there can be exceptions, but there needs to be a caveat. According to Justice Subba Rao, it becomes very pertinent to inquire that whether putting the defendant under strict liability will assist in the enforcement of the regulations. Justice Subbarao is very much concerned on the ground reality. Justice Subbarao is concerned about the carceration nature of such an action, which the majority bench is trying to proceed with. Justice Subbarao is concerned about the implications, the consequences. As we have discussed earlier, that one needs to also be aware of the fact that there are not produced luckless victims when we are talking about the strict liability offences. Justice Subbarao tries to uphold that observation. Justice Subbarao observes that mere fact that the object of a statute is to promote welfare activities or to eradicate grey social evils is in itself not decisive of the question whether the element of guilty mind is excluded from the ingredients of the offense. So Justice Subbarao is agreeing to the fact that there needs to be stringent actions for the socio-economic offenses. But Justice Subbarao wants the actions to be furthered in a very precise manner, in a manner which obeys the due process of law. So Justice Subbarao is laying stress on the language of the statute, but he's also trying to make a very important point here that one should not read mens rea into the language of the statute, even if the statute itself do not talk about the mens rea. The words like knowingly, willfully, if these words are missing, one needs to again go back to the purpose and the objective of the statute. Lastly, it was observed by Justice Subbarao that Section 8 of the Foreign Exchange Regulation Act, it does not contain an absolute prohibition against bringing or sending into India any gold. So Justice Subbarao talks about the language of the provisions. Justice Subbarao talks about the missing links that the majority bench has ignored. Justice Subbarao says that there needs to be some years laid towards this very important observation, that there was no absolute prohibition of bringing gold inside the territory of law, because there was a condition of manifesting it. And if this manifestation allows you to bring gold, then it ultimately implies that there was no absolute embargo on bringing the gold. Ultimately, with this kind of observation, Justice Subbarao thinks that many innocent persons could be implicated. They could be made victims of law. And ultimately, Justice Subbarao holds that the appeal, in his opinion, should be dismissed. And one should look at the very important aspect, which is the due procedure on how one should read the law. It should have been followed. Now to concluding the observations taken by the court. I usually tell my students regarding a very important debate of Justice Breyer and Justice Scalia of US Supreme Court. Their debate between how one should interpret the Constitution, although we are not talking about Constitution here, but the rules of interpretation that these two honorable judges talk about. The video is available on YouTube. It is very, I find it very important. So here, those two judges talk about two kinds of ideologies. They talk about evolutionists and they talk about originalists. In the light of this evolutionists versus originalists debate, we need to understand the positions taken by the two benches, the two opinions here in Emmett George case. we have Justice Iyengar talking about the long-sightedness of the court, talking about the social evils, talking about the socio-economic offenses, which are going to cause grave injuries to our national economy, to our social fabric. We have Justice Iyengar talking about how judiciary should give a proper support to the language created by the legislature. On the other hand, we have Justice Subba Rao talking about the same thing, talking about the long-sightedness. But as I said earlier, he talks about a caveat on how to achieve that end of eradicating the menace of socio-economic offenses. And also, I would like to comment about the historical background of this case. This case was of 1965, and if we look at the scenario at when this case was adjudicated, we see that Santhanam committee was at work in 1962. It was called by the late Prime Minister Lal Bahadur Shastri ji, and the report was of such a merit that in 2003 we created the Civil Vigilance Commission, which was in 1962 envisaged by the Santhanam committee. We also witnessed that in 1963-64 the Law Commission was working on the 29th report, which for the first time in the post-independent India talked about the socio-economic offenses. So we then, if we look at all these aspects, we try to we can try to give a justification on how the majority bench took the decision of eradicating such socio-economic offenses. But we have to also keep in mind, I would like to give this suggestion to all the budding lawyers and to my students, that we also have to look at the due procedure, the due process of while we are eradicating the socio-economic offenses as contemplated by Honorable Justice K. Subba Rao. With this, I would like to conclude my discussion. Saurabh Rana Sirji, over to you.
Thank you, Jatin. Thank you. I believe you have successfully narrated the case, dissected it in all the possible ways, also told about the historical perspective of the case, which is so very important to understand a case in a holistic manner. It was so wonderfully presented by you. And as you told that this is the first case in the case material of LLB students. So this is kind of an entry point for them. This is a very vitally important case for them because they are beginning their journey in the field of law. And I'm sure, Jatin, that you, by narrating it in such a wonderful way, you have made their entry as well as their further journey into the field of law. You have made it quite easier for them. I am thankful to you, Jatin. Now the floor is open for the students. If they want to ask any question, you can ask a few questions here. My dear students, you have 5 minutes for that allocated.
So I have a question. Can I ask?
Yes, please go on.
Yes, thank you. My question is simple. It's that how does Justice Iyengar bring about a distinction between cargo and personal luggage? Because if you say both are one and same, then one person can't even wear a thing, if that's good. we should mention it in the cargo transshipment. So how does that work?
Mohammed, can you repeat your question? Your voice was breaking.
Okay, let me break it down. See, how does Justice Iyengar bring about distinguish between cargo and a personal luggage? If you say the cargo and personal luggage are one and the same, then a person can't even wear a ring unless he can mention it in the transshipment cargo.
Okay, thank you, Mohammed. So the question put up by Mohammed was how Justice Iyengar differentiates between the cargo and the body, the gold carried on one's body, and how it can be interpreted from the term cargo. So, in my opinion, Justice Iyengar brings out the differentiation between these two in a very simple manner. Justice Iyengar says that one cannot give this differentiation of carrying a gold on one's body and one's body on an aircraft being considered as a cargo. So Justice Iyengar is of the opinion that if we take this differentiation, that the respondent here is given a relief that he is not to be considered as a cargo, but as a person carrying gold on himself. Such kind of distinction will defeat the purpose and object of the act which is in question. So this defense taken up by the respondent, it holds no ground according to Justice Iyengar, and if such a distinction is promoted, as I said, it will be defeating the purposes and objects of the act which is in question, and it will lead to further deteriorating of our national economy and foreign exchange, which is vital to the Indian economy. Thank you so much.
Any other question, students? If anyone wants to ask any question. Thank you, Jatin. Thank you so much.
Thank you for
becoming a part of this seminar today. As a young colleague, I have always admired you for your capabilities. You are a wonderful speaker, and I hope that you do wonders in your future. I wish you very best for that. Thank you, Jatin. Now, I would call upon our guest of honor today, Professor Dr. R.N. Sharma ji. He is Dean and Director, School of Law, University of IMS Unison University, Dehradun, to share his opinion on the topic. Professor Dr. R.N. Sharma ji. Sir, Professor Saab,
Professor Sharma, you are not audible.
Professor sir,
Please ask him to disconnect himself and then reconnect again.
Okay.
It may help him
Nitesh, can you
probably
help?
to join us.
Dr. Nitesh, can you help?
Yes, I'm calling right.
I think there is some technical issue there. Sir has joined. Yes, sir, we can see you, sir. You are visible. But, sir, you put on your mic, sir. Mic. Sir, mic. Yes, sir. Yes, sir. Now you are audible. Yes.
Okay.
Yes, sir. Yes, sir. You may start now.
Yeah.
Dr. Ram Nivas Sharma ji, sir.
Good afternoon to all.
Good afternoon, sir.
Honorable Justice Tyagi ji, Professor Mahavir Singh ji, Madam Gupta, Kiran Gupta, Madam Pinky Sharma, Mr. Saurabh Rana, and other faculty colleagues and my dear students. My presentation will be somewhat different from what has been presented by Mr. Jatin Kalon. He emphasized the practical aspect of that, and I will be dealing with the theoretical aspect of this. So my presentation will be based on the socio-economic crimes and presumptions regarding mens rea. So I have started the discussion with the meaning of the term actus non facit reum nisi mansit reum. So sometimes we say that if there is no guilty mind, there is no offense. So blameworthy condition of the mind is a primary condition for the commission of a crime. But when we talk of some statutes which have been enacted especially for dealing with the socio-economic crimes or dealing with the special types of offences, those we can categorize as statutory offences or statutory laws. So these statutes, when create the law, create the offense, then it is said that they are required to be strictly interpreted, and every definition which creates the offense by that act has to incorporate the element of mens rea in that. If there is no element of mens rea incorporated in the definition of the offense given in the statute, the language is clear that there is no requirement of mens rea, then mens rea will not play an important role as it plays important role in the Indian Penal Code. So the mens rea, in these terms, when we talk of, we can think that it can be rebutted by the general rule which says that mens rea is essential for the commission of the crime. Then why mens rea is included in that? There are certain general laws also where mens rea is also not required, like public nuisance matters, in the contempt of court cases, and in the cases of libel, where mens rea is not required. Why it has been made that mens rea is not an essential ingredient of the offense in such cases? Because it is very difficult to prove mens rea in such cases. And as if they were prosecuted under social welfare legislation, a purposive construction was required to further the objectives of the act. And punishment in these cases is usually very light. And these offences are in the nature of mala prohibitia, that is prohibitive in nature, that you should not do this act. Not mala in se, means actually in action is not required. So when we say that these offences are called mala prohibitia, they are prohibited, that you will not commit the contempt of court, you will not go for the public nuisance, and you will not commit the offence of libel. So there the procedure of mens rea is not required. So when we talk of these comparatively, then we can arrive at a conclusion that mens rea doctrine has suffered an eclipse. But the situation is altogether different. I have tried to explain these situations where we can say that mens rea has not suffered any eclipse. The socio-economic offences are considered grave wrong because they affect not only the health and material welfare of the individual, but also the economic structure and social fabric of a nation. This is what in M.H. George case the Supreme Court has propounded. Second aspect, which says ignoring the concept of mens rea, is that socio-economic offences are committed by middle class and upper class people of the society in course of their trade, business or profession, because they are playing the havoc with the economy of the country, social fabric of the country. So in such a situation, those people who are working to multiply their income, multiply their money, and they are playing havoc with the country. So in such cases, they should not be allowed to incorporate in their offense that I was not having mens rea for commission of the offense. The next aspect is that socio-economic offences do not carry with them any stigma. A person who is very big, he might have committed not many offences, but because of his money, he tries to play with the public at large. So that way, he does not carry any social stigma, whereas if a person has committed rape or murder, he will always carry with him a social stigma. So these things, if we keep in mind, then we can say that the features of the socio-economic crimes are that firstly, motive, which we are concerned with the mens rea. Unlike traditional offences, here the motive of committing the crime is excessive greed or desire for wealth. Emotions, where most crimes are done due emotional reasons. On the contrary, these types of offences contain no emotional background or relation between the victim and the criminal. In other crimes, we can see the relationship between the victim and the criminal. But in socio-economic offences, there is no direct relationship between the victim and the criminal. Society or nation is the victim and criminal is one person or two persons. Then target victim. Mostly the victim in such offences is the state or the sector of people, most likely those who are consumer of certain goods or services, a shareholder or having any other securities. So this indicates that the victims are of large number, not individual one or two. Then what is the mode of operation? The main element of commencement of such crime is fraud and not force. In the offences which are covered under IPC, they are covering the aspect of force with them. But here in socio-economic crimes, the role of fraud is more. Then last is the element, mental element. Such offences are usually done deliberately and willfully. So because of this aspect, deliberately and willfully, the doctrine of mens rea has not been made applicable in such type of legislations. Then what are the causes of socio-economic offences? I am just proposing what would have been the framework in the mind of the judges who has decided the M.H. George case. So these factors would have played an important role in deciding the M.H. George case accordingly. In our country, few main causes of emergence of socio-economic offences are industrial revolution, I will not dwell upon in detail, World War, then business, competitiveness, technology. One of the aspects which changed our country for better is also responsible for causing such offences. The emergence of technology and scientific developments led to the decrease in belief of the Almighty. Lack of morals, as the fear for the ultimate judgment or the world beyond all humanly things started to disappear, people's morals and ethics started to decline. This resulted in the increase in frauds and also greed and lust for materialistic happiness. Then, laissez-faire. The state decided to leave things as they were, and lack of public resentment resulted in grave consequences, which is now noticeable in our country. But with proper study and attention, these crimes can be controlled in the country. So these are the causes of the crime. If we tackle these crimes after thorough investigation, we can enact the laws which can help in reducing the number of socio-economic crimes. Then we come to main aspect, presumptions requiring mens rea. Where a statute creates an offense, it is usually understood to be silently requiring that the element of mens rea be imported into the definition of the crime defined, unless a contrary intention is expressed or implied. Hence, the plain words of the statute are read subject to a presumption, which may be rebutted, that the general rule of law that no crime can be committed unless there is mens rea has not been auspiciated by the particular enactment. These laws are strictly required to be applicable. They are strictly construed without requiring mens rea in commission of the offences they create. This
just a moment.
the society at large. So, but we can definitely say that presumption of mens rea cannot be applied universally. But where there is a statute, it can be inferred that the legislature intended that such activities should be carried out under conditions of strict liability. In such cases, we can leave aside the presumption of mens rea. But it should also be considered that strict liability will assist in the enforcement and observations of the regulations. There are two conditions which must be satisfied if the presumption as to mens rea is to be rebutted. Firstly, that strict liability must be required to give practical effect to the legislative intention. Somewhat, to some extent, this very aspect has been dealt by Justice Iyengar in M.H. George case. Secondly, the person charged with a breach of the statutory requirements must have had some opportunity of furthering their observance. So, what is practical? What will be the practical effect of presumptions in favor of the mens rea if the legislative intention is fulfilled and it is in furtherance of the objective sought to be achieved of the enactment? Then the condition of presumption as to mens rea can be rebutted. So then presumption not used in statutory offences. If there is no requirement or presumption, then it is an exception. In offences which can be linked with public welfare and national interest, statutory offences, accused can be punished without mens rea on the part of him. This generally does happen, but in certain other cases, the element of mens rea is somehow or the other incorporated into the definition of the statutory offences, thereby helping out the accused. So, if the socio-economic offences or statute wants that mens rea will be one of the primary condition or prerequisite condition for proving the guilt of the accused person, then it should be incorporated in the definition itself. If that is not incorporated in the definition, then it can be exempted, or no, there will be no requirement of mens rea and he can be punished simply on the basis of the possession or statement, whatever the case may be. When mens rea is expressly excluded from the statute, in case where mens rea is not taken into consideration and the accused is strictly held liable, where the accused has a guilty mind or not, he is liable for the act done by him. So in such cases where it is expressly excluded, then mens rea will not play an important role in proving the guilt of the accused person. Then where statute is silent as to the requirement of mens rea. Sometimes a statute is silent on mens rea, nothing is said about the guilty intention of the mind. In such cases, mens rea can be presumed. Where mens rea is of mild type, in such cases, merely knowledge is enough to constitute an offense, as was expressed by Justice Subbarao in M.H. George case. Then third case is of vicarious liability. The following are the some of the reasons suggested for the recognition of the principle of strict liability. Although almost all such offences are of minor nature and involve only pecuniary penalty, and exclusion of inquiring into mens rea is not unjust, where the only outcome of the prosecution is a small pecuniary penalty. It is difficult to procure adequate proof of mens rea in such offences. Public welfare legislation serves a social purpose by making an act punishable, which though not intrinsically wrong, but which is punished in the public interest. The number of transgressions that have brought before the courts, the defendant is probably culpable. While the proof of this mental culpability is difficult, it would be waste of time for the court to have an inquiry into the question. Another argument in support of strict liability is the claim that it serves as a proof to stimulate increased care and efficiency even by those who are already careful and efficient. Then the Santhanam committee of which Mr. Kalon has talked about, he referred certain things and he said that these things are endangering the economic health of the country. First is the evasion and avoidance of taxes lawfully imposed, misuse of their position by public servants in making the contracts and disposal of public property, issue of licenses and permits and similar other matters, delivery by individuals and industrial and commercial undertaking of goods not in accordance with agreed specifications in fulfillment of contracts entered into with public authorities, profiteering, black marketing and hoarding, adulteration of foodstuffs and drugs, theft and misappropriation of public property and funds, and trafficking in licenses, permits, etc. So most of these offences have one common element of economic benefit in terms of actual monetary value or advantage in terms of comparative enrichment to the perpetrator of the offence. These crimes are very important for the society and to protect public interest. Hence, if a statute is enacted to recognize them as criminal offences, they would be categorized as statutory offences, or in other words, we can say these are the socio-economic offences. Then I have tried to classify the socio-economic offences. White collar crimes, these deals with the restraint of trade, misrepresentation in advertising, rebates, infringement of patents, trademarks and copyrights, unfair labor practices and financial manipulations, etc. Second category is of public welfare offences. These are illegal sale of intoxicating liquor, sale of impure or adulterated food or drugs, sale of misbranded articles, violation of anti-narcotics acts, criminal nuisances, violations of traffic regulations, violation of motor vehicles laws, and violation of general police regulations passed for the safety or well-being of the country. And third type of socio-economic offences is victimless crimes. These crimes are created when we attempt to ban through criminal legislation, the exchange between willing partners of strongly desired goods and services, like that of prostitution. Now, I have talked about the Law Commission's 47th report. I will be skipping this PowerPoint. So, the 4 points which has been discussed in State of Maharashtra versus MH George case are, which can be said to be the landmark propositions for arriving at whether the principle of mens rea will be applicable or not, whether the presumption in favor of mens rea will be taken care of or not. First proposition is that phraseology of the statutory provision creating an offense of strict liability, particularly expressions indicating or excluding the mental element required. So first thing in this case was expressed by Justice Iyengar, that the statutory provision should expressly either exclude or indicate that whether mental condition is required or not. Second, you have to look into the objective of the statute. Third proposition is that nature of public purpose purportedly preserved by the statute. What was the purpose for which this statute was enacted, whether it was for the public benefit or for individuals' benefit. Then nature of the mischief at which the provision or statute is aimed, and whether the imposition of strict liability will tend to suppress the mischief, although strict liability should not be inferred simply because the offense is described as a grave social evil. So here in the fourth proposition, principle of interpretation, mischief rule has been incorporated. What was the mischief? What was the position of the law? And for what the law has been enacted? These all three things have to be kept in mind while giving meaning and content, and to adopt the principle of presumption in favor of mens rea or not. Hence, it is my observation, in spite of the developed rules regarding the application of presumption, it still depends on the facts of the case, as well as the type of statutory offences, whether the presumption will be applied or not. And the courts will still keep developing new rules to decide the same. So what I want to say is that the State of Maharashtra versus MH George case is not the final version. What the court has propounded in 1965, it may be changed, keeping in view the different set of facts and different principles which are being made applicable by the court in subsequent cases. Then I have discussed another case, which is in 1996 only, Nathulal versus State of Madhya Pradesh. It relates to Essential Commodities Act. In this case, what happened was that a appellant was a dealer in food grains at Dhar in Madhya Pradesh. He was prosecuted for sale of wheat without a proper license for the same. And he was charged under Section 7 of the Essential Commodities Act 1955. Additional district magistrate acquitted him on the ground that he did not have any kind of guilty mind. He deposited the required fee and stored the grains only after applying for license, and in anticipation of that, it would be issued. So what happened in this case was that he applied for storage of the food grains and deposited the fee, and he was under the impression that I will get the license for the storage. And he stored that, though the official order has not come. So in appeal, Division Bench of Madhya Pradesh High Court set aside ADM's order of acquittal and convicted him. Because they applied that the mens rea is not required. Guilty intention is there or not, so it cannot be looked into. The case ultimately went to the Supreme Court, and Supreme Court, the issue involved in this case before the Supreme Court was that the act of appellant violated Madhya Pradesh Food Grains Dealers Licensing Order and the role of mens rea in the case. This was the issue involved in this case. The Supreme Court held that the fact that licensing authority did not communicate to him the rejection of his application confirmed the accuser's innocence, and he did not intentionally contravene the provisions of Section 7 of the Essential Commodities Act. So ultimately what happened? The licensing authority rejected his application, but they failed to communicate it to the appellant. Under this situation, the court held that though appellant had contravened the provisions without mens rea, but it was state authorities that acted negligently. So the negligent act on the part of the state authority cannot be a ground for conviction of the appellant. They did not allow him to hearing before rejecting his application for license and did not even inform him about its rejection. So with these arguments that he has not been given opportunity of being heard before rejecting the application, and he was not informed about the rejection of his application. So court, keeping these aspects in view and the negligency on the part of the state authorities, cannot be a ground for conviction of the accused person and acquitted the appellant. Same is the case, another case which I have discussed under the Income Tax Act, wherein in a suit or other proceedings under the Act, in which a court or any other body or person exercising authority under the law has to pass a decree, judgment or order casting an obligation or liability on or affecting the rights or interest of any party to the proceeding, the important questions that arise in this act are: what are the essential elements of statutory provisions? On what party does the burden of proof various elements of the provision lies? What degree or quantum of proof is needed? And under penalty and prosecution provisions of any statute, first two questions can be reframed as follows: are actus reus and mens rea both essential ingredients of penalty and prosecution provision under the Income Tax Act or not? Or second point was, on whom does the burden of proving these elements lies? Now, under the Prevention of Corruption Act, Section 7 and Section 11 of the Prevention of Corruption Act says that public servant, if he found in the undue property in his possession, or he has accepted the bribe, then undue advantage which has been given to the person can be presumed. So this is all about the proof of dishonesty either by himself or by other person may or may not be considered by the court. Then the Prevention of Food Adulteration Act. Under the Prevention of Food Adulteration Act, sale, etc. of certain articles of food, no person shall himself or by any person on his behalf manufacture for sale or store, sell or distribute any adulterated food, any misbranded food, and if they are found in the possession of that person, then it will be presumed that he is having these goods in his possession voluntarily or with malice intention. It will be presumed that there is a mens rea. It need not be proved separately. Then Narcotics, Drugs and Psychotropic Substances Act, same is the case, where if any contraband or psychotropic substance is found in the possession of any person, then guilty intention need not be proved. Mere possession is proof that he is an accused person and he has committed the offense. Same is the case of Immoral Traffic Prevention Act 1986. And more importantly, the presumptions under section 113B of the Indian Evidence Act, when the question is whether a person has committed the dowry death of a woman, and it is shown that soon before her death, such woman has been subjected by such person to cruelty or harassment for or in connection with any demand for dowry, the court shall presume that such person has caused the dowry death. So there is no requirement of mens rea to be proved to get the conviction of the person. Same is the case under the offense committed under section 376 of the IPC, which is covered under section 114 of the Indian Evidence Act. Then in this regard, the Law Commission has recommended certain measures. Before recommending measures, they have pointed out that what are the defects in enforcement of socio-economic offences. Firstly, the absence of proper legislative provisions. Second is the absence of the relevant statutory notification. Third is the faulty investigation. Fourth is the lack of legal expertise. Fifth is the procedural drawbacks. Sixth is the want of evidence. And last is administrative difficulties and defects. So the Law Commission in this respect has suggested following measures: stringent action, departure from conventional mens rea and burden of proof doctrines, increase in minimum and maximum year of punishment, then special court should be established to meet out the situation. Appeal should be from a special court directly to the High Court. Then mandatory provision for imprisonment should be there. Simply awarding fine will not work. Need for preventive detention laws should be made applicable in such cases, and stoppage of business or cancellation of license and probity. So these are the measures which has been suggested by the Law Commission to make the socio-economic laws more stringent. At the end, I would like to give the practical example. When I was practicing as a lawyer in Rajasthan High Court from 75 to 78, I give you the example which I have contested. One Mr. Bankat Lal was arrested under the Essential Commodities Act, and in whose godown hundreds of tins of oil and food grains and adulterated food of other nature were found. They were seized, confiscated, and he was prosecuted under Essential Commodities Act. Meanwhile, the samples collected of food items were sent for examination to the State Food Laboratory. State Food Laboratory submitted its report in 7 days, and it was found that oil was full of turbidity and it was not fit for human consumption. That person approached the Chief Judicial Magistrate Court through my senior with whom I was practicing at that time. CJM refused to accept the bail, went to the Sessions Court also rejected the bail, went to High Court also rejected the bail, and the matter went to the Supreme Court. Supreme Court said that we are not going to look to the intention of the party because lot many goods have been found in his possession, and that too against the violation of a socio-economic offense, socio-economic act, with Essential Commodities Act. He was a hoarder. He hoarded lot many goods of food items, and people were scared of that. So that way he he was not released on bail by the Supreme Court. The matter was broadcasted in the BBC London. BBC was the main broadcaster at that time in 1976, 77, and he cited that case that we have not seen such a turbid oil. It was 100 times more turbidity which was available in that oil. And the Central Food Laboratory also opined that he might have used anything which is not consumable by a human being at all. And ultimately, he remained in jail for 9 months. And later on, when all these samples were examined again and again 3 times, then he got released on bail by the Chief Judicial Magistrate. So this is the factual case where we have pleaded that mens rea does not play an important role, or there may be a presumption of mens rea while dealing with the accused persons who have committed offense under socio-economic crimes head. So with these words, I think I have taken more time which was allotted to me. I am very much thankful to the organizers for inviting me to have an interaction with the students of Law Center 2, Faculty of Law, Delhi University, and I have an honor to present my views in the presence of Justice Tyagi and Mr. Mahavir Singh ji, Madam Gupta and Madam Pinky Sharma. I am again sincere thanks to Mr. Saurabh Rana who contacted me and requested me to present my views. Thank you.
Thank you, sir. Your coverage was wide from your own practical experience to the Santanam Committee recommendations, to the Income Tax Act, Prevention of Corruption Act, Food Adulteration Act, NDPS Act, Dowry, Death, and whatnot. Sir has not left any aspect untouched. Sir very well said that it is as per the language of a particular statute that mens rea is excluded or included. Sir has very aptly said and distinguished between what we know as traditional crimes and, on the other hand, what we call socio-economic crimes. And that difference is the foundation of separate treatments of the 2 sets of offenses by the criminal justice administration system. Now, I throw open the floor for students' questions. Students may ask a few questions.
Good evening, sir.
Hello, good evening.
Good evening, good evening. Yes, please.
My question is, how can we expect from a foreigner to know the law of a particular country? Like, how can we prove that he literally has a guilty mind? Maybe it was an emergency for him to land in that country or whatever the case may be.
You might be aware that there is a presumption that even a hawker is supposed to know the law of the land. Secondly, ignorance of law cannot be pleaded as a defense that I have not committed any offense. If I would have known this law, I would not have committed the offense. So if this defense would be made available to everyone, then I think everyone will get the excuse. I can murder a person and later on I can say that if I would have come to know that this will be an offense, I would not have committed such an offense. So ignorance, whenever a person lands at the country, at the earth of the country, India, then he is supposed to know the law of India. Irrespective of the fact whether he actually knows or not. Even I cannot claim that I know all the laws, but it is presumed. It is a presumption. Mens rea is not at all covered here.
Thank you, sir.
Very well said. Any other students? Sir,
there is a question related to MS George case. If a person is related to a person is a transit flight, technically he is not visiting to our country. So how we can apply Indian law upon him?
So far as I can answer your question, because the flight was landed in Indian territory, and when that flight was on Indian territory, it is presumed that that person was having committed the offense on Indian territory.
So can we ask a counter question of?
Yes,
go ahead.
So if you want to enter in a particular territory of any country, you need to visa for a particular country to visit there. So
visa may or may not is a separate condition, but that actually it is a technical issue. What you have raised is a very technical issue, because he was not having visa of India. He was in transit and was to go to other country. He should not have been handled here in India. But the situation might have occurred that this person may deliver some of the gold in Indian territory. That way they might have got him. It is only an imaginary answer.
Thank you, sir. Thank you. The time is not allowing us to continue with the question session. Thank you, sir, Professor R.N. Sharma, sir, for joining us today on behalf of
all the team of organizers and the participants.
Thank you, sir. We are greatly honored. Thank you. On behalf of Law Center 2, I express my deep sense of gratitude to you, Professor R.N. Sharma, sir, to enlighten us on the topic. Now I would call upon His Lordship Justice A.K. Tyagi ji, Honorable Judge, Punjab and Haryana High Court, to share his views on the topic. Honorable Justice Shri A.K. Tyagi ji.
Good evening to all of you.
Good evening, sir. Good evening.
So first of all, I want to make a disclaimer. I am not an expert on the subject, and I'm just an average student of law. I am expressing my views as a student of law. So I also want to take some liberty. So Professor Ramnivas Sharma, Dr. Mahavir Singh, Dr. Kiran Gupta, Mr. Jatin Kalon, Mr. Saurabh Rana. I am very thankful to all of you. I have heard the speakers who have spoken on the subject, and the chief guest always has a problem, because whatever the subject admits, or it is already spoken about. So this will be my problem also. And Professor Ramnivas Sharma has Mr. Jatin Kalon also, and Mr. Ramnivas Sharma. They have already covered the subject. Now, first of all, I want to take some liberty. If Dr. Mahavir Singh and Mr. Saurabh Rana will permit me, I want to take some liberty.
Sir.
Starting on the topic, I want to say sidetrack.
Please go ahead, sir.
Please, sir.
So I want to refer to stories. I know the law students will seek my please, Mr. Saurabh, can I share my screen?
Yes, sir. Please share.
Please, how to do it? I'll have to just assist me, please.
Yes, sir. Yes, sir.
So first of all, I want to express my gratitude to the teacher, to my teacher. I was a student of law in first year. I studied from Law Center 2.
Yes, sir.
So I am very grateful to all my teachers, and I still remember what was said to me. One of the, you can forget everything in life, you cannot forget good teachers. So you will
Thank you,
always remember them, and I always remember my teachers, Professor Upendra Bakshi, Professor B.T. Kaul, and all others. I am mentioning two names, but that doesn't show that I am not referring to all others. I am very grateful to them, and it was their blessings and inspiration and their guidance that enabled me to achieve what I can say it was all due to them, because of their guidance and inspiration. So to the students, before I come to the topic, I want to share some stories. And these stories are conveying the values. I have captioned them. So first, I am referring to 3 questions taken from a story written by Leo Tolstoy, compiled in book, The Greatest Short Stories of Leo Tolstoy. I think you are able to see the screen.
Yes, sir.
Yes, sir, we are able to see. It is visible, sir.
First question was, what is the best time to do a thing? Present is the best time to do a thing. Who are the best persons to be associated with? Persons around you are the best persons to be associated with. What is the best thing to be done? Task in hand is the best thing to do. So I have again said, let us all comply. So I am enjoying. So enjoy what you are doing. 3 laborers breaking stones were asked as to what they were doing. First replied, he has nothing else to do. Second replied, he was rearing his family. Third replied, he is building a beautiful temple. So let us all build a beautiful temple of justice. This message to the members of legal fraternity. Your conscience is always watching you. This is the story which I have included. On being asked by his disciple as to what Guru Dakshina was to be given, the teacher told him to bring anything by stealing from his home when nobody was watching him. When the disciple did not bring anything even after expiry of long time, the teacher questioned him. Why? And he replied, there was never any time when none was watching him. The teacher again questioned him. Was there never any occasion when he was alone? And the disciple replied that there were many occasions when he was alone, but his conscience was always watching him. So we have to listen to our conscience always. And next, we all make a contribution to our society. So the king, desirous of filling a pond with milk, ordered his citizens to contribute milk to the pond in the night. In the morning, the pond was full of water. The reason? Everyone thought that when others would be contributing milk, it would make no difference if he contributed water. So we have to take care of our contribution to the society, and we have to make earnest efforts for making a significant contribution. Now the setting sun asked, who will dispel darkness after me? And the tiny Otherland said, I would. So wherever we are, whosoever we are, it's our contribution which matters and not our position or status. So we must, I am now requesting all these students who have joined that we must all dispel this darkness. So please next, if you can. And then Mr. Saurabh, Dr. Jagdish and Mr. Saurabh, I'll take one more permission. I want to tell them why we need law. So I want to share with them my experience as a student when I joined the Law Center too. So maybe that experience of many of them will also be similar. So the first question when we joined law, the question was, why do we need the law? And I have put it next, good man follows norms of conduct without its presence, and bad man does not obey despite its enactment. Yet, rule of law and administration of justice are essential to the very existence of a civilized society. And then what is the purpose of legal education? Not acquisition of knowledge of law, but creating an eagerness to know the law. And that is why I say law is such a vast field that you cannot master it. You can only know part of it. You cannot even know the full of it. or even on a particular subject. And then the only acquisition will be that you always remain a student of law, eager to learn every day, every second, every moment. So next, I am again the questions which our teachers asked us to imbibe, the basic questions for acquiring knowledge of the law. So these 6 questions I found always useful in my entire career. Where is the law on the subject? What is the law on the subject? When it was enacted? Why it was enacted? To whom it applies and who are exempted from its application? And how it is applied. So please, next I want to, and now I'll come to this judgment of the Supreme Court. So before I come to the judgment, first, before beginning, I will also like to make a comment about the judgment which is on the screen. Mr. Jatin told me that it is the first judgment which is in their syllabus with which they will begin. And I say that it is a very good judgment which has been selected. It is having such a vast field of for knowledge, and it is presenting also in its contents the skill for arguing, the skill for application of law, and also the skill for distinguishing the facts and circumstances of other cases. So just another slide, please. Yes, the facts. Mr. Jatin had mentioned the facts, but I have also repeated them, but I will not go through them. I'll just now begin with this maxim, actus non facitrium nisi mancitria. There would be no offense unless the prohibited act and the guilty mind coexist. So actus rea and mens rea must exist together. Now, I'll not be going in not to the details of these concepts at this moment, because I take this opportunity to share something else with the students. I found that this judgment, and I say this judgment contains the entire statement of law. If I can say, this is 3 aspects. First aspect, this is Chief Justice Goddard in Brand versus Wood. He highlighted 2 aspects. So first is that it is, I am reading from it. I am quoting from his judgment. It is of the utmost importance of the protection of the liberty of the subject that a court should always bear in mind that unless a statute either clearly or by necessary implication rules out mens rea as a constituent part of a crime, the court should not find a man guilty of an offense against the criminal law unless he has a guilty mind. So this is statement 1. Now the statement 2 is, there are statutes and regulations in which Parliament has been fit to create offences and make people responsible before criminal courts, although there is an absence of mens rea. Now this is statement 2. Now I'll also refer to the observations of Justice K. Subba Rao. That is that mens rea is a constituent part of a crime unless the statute clearly or by necessary implication excludes the same, and the application of the same to a welfare measure is an indication that the court shall not be astute in construing a statute to ignore mens rea on a slippery ground of a welfare measure unless the statute compels it to do so. Just now, can you give me this second slide? I'll just show them. Then this, in this judgment, facts Mr. Jatin had mentioned the statutory provisions involved were Section 8(1), read with Section 23(1)(a) of the Foreign Exchange Regulation Act 1947 and Section 167, subsection 8 is 1 of the Sea Customs Act. So I am just mentioning on the screen that the magistrate said convicted and sentenced to rigorous imprisonment for 1 year. Bombay High Court acquitted. Supreme Court majority view set aside acquittal, restored the judgment of conviction, modified the sentence to already undergone. While the minority view was that he is not guilty. Next, please. The Supreme Court judgment. And I found the judgment to be such an excellent work piece. Of course, both the majority view as well as the minority view. So you happen to read when you read this judgment, so you will first read the minority view. And when you read the minority view, you will perhaps tend to agree with the view taken by Justice K. Subba Rao. You consider that what his lordship has said is absolutely correct, and this should have been the judgment. But thereafter, you read the majority view given by Justice N. Rajagopala Iyengar, who spoke for himself, and Justice J.R. Mudalkar. So this case I found involved 3 questions. Arguments, the lawyers for the parties, Mr. Surabji as well as the learned Solicitor General, they addressed the arguments which I found were excellent arguments. And I have just tried to, but I am not referring to the judgment, those their arguments, because their arguments are already covered by the points which I have enlisted here. I am referring to the minority and majority view in comparison to, in a comparative table. So the one point was whether this section 23(1)(a) excluded mens rea or not. So whether mens rea equated with knowledge of the existence, here I will like to say that mens rea varies as per varied offences. It may be intention, it may be knowledge, it may be reason to believe, likewise. So before I begin with this judgment, I'll also like to add one more thing. The Indian Penal Code applies this doctrine, this maxim in two ways that all students will already be knowing, and my speakers before me who have dealt with this subject have already specified it. IPC, one is that the statutory provisions defining offences have specifically mentioned the state of mind required for constituting the offence. This is one method. And second is that is presence of mental state that is specifically mentioned whether the offence requires it or does not require it. Or if it requires, which kind of mental state is required. The second is exclusion of mens rea. That was presence of mens rea. And then exclusion of mens rea. I am saying exclusion, not in the sense of a specific exclusion. I am saying allowing those defenses which exclude mens rea. So private defense, mistake of fact, insanity, likewise. Where there will be no mens rea, so those defenses are allowed to the offenses. Now I come to this judgment. So in this judgment, that I said whether a statute excludes mens rea or does not, so tests are laid down. I'll also come to them, but I want to just first refer to this. First question involved in this case was whether I'm putting it other way around from the facts. I'm first going to the question of law. So first question involved was whether mens rea equated with knowledge of the existence and contents of the RBI notification dated 24th November 1962 is an essential ingredient of the offence. So So the majority view was that mens rea was excluded. The act dealt with the evil of gold smuggling and also the necessity of preserving foreign exchange. So the object of the act could be achieved only if the mens rea was excluded. So the majority view was that exclusion of mens rea was necessary to implement the object of the statute. So therefore, they said mens rea is not part of the offense. But the minority view was that mens rea is not excluded by necessary implication. Exclusion of mens rea was not necessary to implement its object, and if this mens rea was excluded, many innocent persons would become victim of law. So here I'll say the test for application of this, for determination whether the statute excludes mens rea or whether it includes it. What will be the test? First of all, the language of the statute. Second, the object of the statute. Third, when we say object, so here we'll see whether the exclusion will further the object or it, and here, and this test, another test with Justice, in his minority view, Justice K. Subbarao has mainly relied, that was based on the judgment in Limchin A versus the Queen. And that was beautifully, I'm quoting from the judgment, observations made by the Judicial Committee. But it is not enough in their lordship's opinion merely to label the statute as one dealing with a grave social evil, and from that to infer that strict liability was intended. It is pertinent also to inquire whether putting the defendant under strict liability will assist in the enforcement of the regulations. That means that there must be something he can do directly or indirectly by supervision or inspection, by improvement of his business methods, or by exhorting those whom he may be expected to influence or control, which will promote the observance of the regulations. Unless this is so, there is no reason in penalizing him, and it cannot be inferred that the legislature imposed strict liability merely in order to find a luckless victim. So this is luckless victim which figures in the minority view. And this test was that where it can be shown that the imposition of strict liability would result in the prosecution and conviction of a class of persons whose conduct could not in any way affect the observance of the law. Their lordships consider that even where the statute is dealing with a grave social evil, strict liability is not likely to be intended. So this is what the minority view has. It has figured mainly in the minority view, which is also based mainly on this judgment. So I am also referring to now the second aspect, which is involved in this case. That is, this is related to knowledge of the provisions, knowledge of the requirement. And that is mens rea, by the knowledge of this notification, when the delegated legislation by way of the RBI notification dated 24th November 1962 came into operation. Here is the element of its publication, how it was required to be published, how the people were required to know about it, and when it would come into operation. So here, the question which was asked, this respondent, he was a German national who came to India while he was going to Manila. So he did not even get out of the aircraft, he was sitting in the aircraft. Now, one thing I want to mention here, that his background, I am saying the judgment also notices it, his background and his conduct. He was a smuggler. This was his background. His conduct, that he, in a jacket, he was carrying 34 kilos of gold. So these two facts Of course, although these have not weighed, and the result, the judgment is based on interpretation of law. So now if a person is coming from outside India to India, how he would know about the law of India? He cannot. Now another thing, if law in India is made and it is to be published, where it should be published? Will it have to be published in the entire world so that every citizen of the world, every person in the world must know it? Or it will be published only in India? So this was the question. This is in respect of a question was asked how a person from outside India would know about the law of India. So ignorance of law is no excuse, and every person is supposed to know it. This is the maxim. So this maxim has been applied in this case also. Justice K. Subba Rao said that this Foreign Exchange Regulation Act 1947 did not have, while it gave the delegated legislation powers, it did not contain any provision regarding publication of the notification. So once there is no provision regarding publication of the notification, it does not prescribe the mode of publication. Reserve Bank of India was not bound to publish under any express provision of statute or rules made thereunder in any particular manner. So knowledge cannot be imputed to the respondent who started on 27th November and landed in India on 28th November about a notification which was published only in India on 24th November. So he says then the notification apply against persons to whose knowledge it is brought. So this is a conclusion which I say which seems very sound on the face of it, but when you make a very deep analysis of this this fact situation, you find that the conclusion is not appropriate. Reason being, first point is where the manner in which publication should take place. So now the Act provides that it should be generally in official gazette. So in this case also notification, RBI notification was published in the official gazette. So even if the Act did not provide for any particular manner of publication of that notification, it was published in usual manner, which was adopted to notify everyone about the laws, rules, regulations which are made. So one more thing I would like to say here in the context of the observations made by Justice K. Subba Rao, that this notification was of a general nature. It applied to everyone who was coming to India. So it did not apply only to the respondent. It did not apply to any particular individual. So there was no necessity of conveying that notification to any particular individual. It was a general notification which will be applicable to everyone coming to India. So it will apply, all will be presumed to know its contents. Now, this is the view which this majority view has taken. Majority view says that even if this Act did not prescribe the mode of publication, it was published in the usual manner. So once it was published, it came into operation on date of the publication itself. And everybody is supposed to know, so the respondent was also supposed to know about its contents. Now, I'll again come to the facts of this case. Again, because the minority view and majority view, minority view was also based on one judgment where I quoted the observations of the Judicial Committee. I also want to refer to them not because as required for dealing with the subject, essentially for elaborating exclusion or inclusion of mens rea in the context of the socio-economic offences, but I want to highlight it in the context of a student learning or analyzing these judgments. So I consider it to be my duty as a student of law that they must also see to this aspect how they should analyze this judgment. and how the judges, it has three important aspects, how the lawyers have argued, how the judges have applied the law. So judges minority view and majority view, when you read both of them, you perhaps while reading one, you tend to agree with the conclusions. And yet the law is by majority, so the majority has to prevail. So third aspect in this case was that this RBI notification required that the person who is bringing gold to India must declare it in this manifest. And he must declare whether he's carrying any gold in this what you call bottom cargo or this transshipment cargo. And the judges have considered what is a cargo and what is the same bottom cargo and what is transshipment cargo. Because this question was put, so I am referring. So cargo, this same bottom cargo is when the gold brought will not be shifted to any other conveyance, then it will be same bottom cargo. And transshipment cargo, the case is, this case falls in this category of transshipment cargo where, where it is to be shifted to a different, it will fall in the same bottom cargo, where it is to be shifted to a different conveyance in the mode of journey, then it will fall in transshipment cargo. So now the question was, this person was carrying this gold in the jacket which he was wearing. So it was not same bottom cargo, transshipment cargo, or it was not in the cargo. So both the majority view as well as minority view, they take the view that what he was carrying on his person is covered by the word cargo. And Justice K. Subbarao he took the view that cargo manifest does not exclude accompanied baggage. Whatever the person was carrying in the cabin, that will be included in the cargo. And just the majority views also, they have slightly interpreted in a different manner. Justice K. Subbarao said that if you both in fact majority as well as minority, they have referred to the situation where if you say that whatever a person is carrying on his person will be covered by cargo, then if a person is having a gold type in, then it will also be covered. Or if some earring likewise. So how to exclude that? So this majority view excludes that. They say what is personal baggage and what is not. There is a distinction between them. So what is not a personal baggage will be in the cargo, and what is a personal baggage that will not be in the cargo. This is, if you read para 17, so this conclusion follows. Whereas para 6, it is a minority view. It says cargo will include accompanied baggage. Just the distinguishing fact, statutory provisions. Now, this judgment, because the minority view was largely inspired by the judgment of this lynching act case. So I have put these provisions on in a comparative table. So before coming to this discussion, I want to notice certain features of these statutory provisions. Now this section 6.2, it said it shall not be lawful for any person other than a citizen of Singapore to enter the colony from the Federation, if such person has been prohibited by order made under section 9 of this ordinance from entering the colony. So prohibition was part of this offense. Only if a person has been prohibited, then if he enters or remains there, then he commits an offense. So first main ingredient is this prohibition. Now other was that this was against this ordinance. This created the offense, and Section 9(1) empowered the minister to prohibit any person for a slated period or permanently from entering into the colony or re-entering into the colony. These were the provisions. And now this was also provided by that ordinance that every order made shall, unless it be otherwise provided in such order, take effect and come into operation on the date on which it was made. So now, as compared to this is based on prohibition. And then because the person continued in the colony, so he was prosecuted because he violated the prohibition order. As compared to this foreign exchange regulation, I'm not reading the entire one because it is displayed on the screen. So no person shall, except with the general or special permission of the Reserve Bank and on payment of the fee, bring or send into India any gold. So this contains a general prohibition, and the only exception is with general or special permission of the Reserve Bank. So unless you have general or special permission of the Reserve Bank, you cannot bring gold into India. This is the provision. Now, this Section 23(1)(a) said it is an offense if you violate this. This says if you violate any of the provisions or any rule, then it is an offense. And the punishment can be up to 2 years. Section 24(1) I'll refer later. The Government of India notification, this was on 25th August 1948. It said it prohibited any person from, no person shall bring or send into India any gold except with the general or special permission of the Reserve Bank. Now this notification of 25th August 1948, it gave general permission. That it said the bringing or sending of any such gold or silver by sea or air into any port in India, provided that the gold or silver is on through transit to a place which is outside both the territory of India and the Portuguese territories which are adjacent to or surrounded by the territory of India, and is not removed from the carrying ship or aircraft except for the purpose of transshipment. So this was the general permission given. So if this permission prevailed as on 28th November 1962, if this provision continued to prevail, then the respondent would not have committed any offense. But this permission had been withdrawn. That was withdrawn on 8th November. That was the notification 8th November 1962. The permission was withdrawn, but it was not absolute. There was no absolute prohibition still. And the permission was that if a person brings gold into India for transshipment outside it, then he must declare it in the manifest for transit as same bottom cargo or transshipment cargo. This was the requirement. So this law which prevailed on 28th November was that you can bring gold into India for its transshipment outside India, but you must declare in the transit manifest. Respondent did not declare gold in the transit manifest, and it would also be appropriate to mention that when he was asked by the custom officers, he said what gold. So he expressed as if he was not carrying any gold. So now I want to just next slide where I have distinguishing facts. So now these distinguishing facts and circumstances between these two cases. Singapore Ordinance, entry was not unlawful unless it was prohibited by an order made by the minister. India, this Foreign Exchange Regulation Act, bringing of gold into India is unlawful unless permitted by Reserve Bank of India. This is the difference. Now, order was made by the Minister 28 May 1959, 10 days after the appellant entered the colony. The same was received and retained by Deputy Assistant Controller of Immigration and was never published. India, it was a notification dated 8th November 1962 was published on 24th November 1962 in the official gazette, which was the usual mode of publication in India before the respondent landed in India on 28th November 1962. Now, because in that under that Singapore case, it was necessary that the publication should have been brought to the knowledge of the accused. Reason, because entering was an offense only if it was prohibited. So whether he was prohibited, he could know only when he was told that he was prohibited from entering in Singapore. Now this, whereas in this, in the case of respondent, notification was published in official gazette. It could not be published in Germany, or it was not required to be published worldwide. So the respondent was supposed to know it under the principle that ignorance of law is no excuse. Now this Singapore case, this case involved contravention of the order of the minister by which entry in the colony was prohibited. This the case Mayor Ernst George. In this case, contravention was in the context of order dated, I'm sorry, this I've put the wrong date. It is 24th, this date is wrong. It is in the context of 25th August 1948, whereby the central government prohibited bringing of gold in India except with the permission of Reserve Bank of India. Now, in Singapore case, the order concerned single individual who was prohibited from entering the colony. In this case, the notification concerned general public regarding rule applicable to everyone coming to India. The Singapore case, the offense involved contravention of the order prohibiting entry. In this present case, this offense involved non-compliance with the condition for permission to bring the gold. That was that he should have declared it in this, in the transit manifest. So like I'll say now referring to the statutes, when the legislature is defining the offenses, the legislature is mentioning the requisites, what constitute that offense. So Professor Ramnivas Sharma has already referred to that Prevention of Food Adulteration Act case, where it was said that if you have adulterated milk in your possession for public sale, you commit the offense, whether you believed it to be pure or whether you believe that it was not adulterated is no defense. Your belief is not a defense. So the reason is that you cannot exclusion of mens rea. It is clear that if you do not exclude mens rea, then you cannot implement the object of the act. Similarly, this Foreign Exchange Regulation Act case, in this also, Justice Subba Rao mainly mainly took the view that mens rea was included because in his view, respondent could not do anything for implementation of the object. Whereas the majority has taken the view that mens rea is excluded because if you don't exclude mens rea and if you make knowledge of the person essential, then you cannot implement the act because everyone will claim that he did not have any knowledge about the notification. And you cannot check, the people will be able to circumvent and you will not be able to prevent and check this violation. So far as IPC is concerned, as I have mentioned, it contains detailed provisions I'm saying the provisions contain detailed specifications which mental state is required, and also contains general defenses where mental state is negatived. So that will be a general defense. Many acts like this NDPS, I will also like to mention that I had referred to that section 24. Now, one is that presumption of mental state. I'll refer to NDPS Act, section 35. It says, Professor Ramnivas has already referred to presumptions created where the court presumes. And one is provision which I want to refer to is section 35 of the NDPS Act, which says, just a minute, I want to take it out. This is presumption regarding culpable mental state. In any prosecution for an offense under this act, which requires a culpable mental state of the accused, the court shall presume the existence of such mental state. So court has to presume. The prosecution, now this also raises this question, who is to prove mens rea? So the general rule, as we said, general rule is that presume inclusion of mens rea, and exclusion will be an exception which you have to determine. So this, again, this general rule will be that the prosecution will have to prove mens rea, and the accused is not required to prove its negative. So, but this presumption, now it puts the reverse burden of proof. Now it says the court will presume the mental state, and the accused will be entitled to prove the fact that he had no such mental state with respect to the act charged as an offense in that prosecution. So now this reverse burden of proof will be there. So in this case also, this Foreign Exchange Regulation Act also contained a similar provision. So can you, this statutory provisions, just. Not coming. I think there's some problem. The provisions one. Yes. So this was section 24(1), where any person is prosecuted or proceeded against for contravening any provisions of this act or of any rule, direction or order made thereunder, which prohibits him from doing an act without permission. The burden of proving that he had the requisite permission shall be on him. So because in this case, mens rea was not included, so the presumption as to mental state is not there. Yet it has put reverse burden of proof on the accused, that he must prove that he had the permission. So one of the conditions for availing the permission was that he must declare it in the transit manifest. So remaining aspects which I have already said, the tests I have also referred. So now I will also like to mention that even the socio-economic offenses, the statute while defining socio-economic offenses also, or other offenses, that may contain specific reference to the mental state required. So for example, I am mentioning one provision of the Companies Act 2013. This provision is intended to prevent fraud. This is punishment for false statement. So this provision, if a person makes a false statement in financial returns, then that will be an offense punishable under section 447 of the Companies Act. And that section 447 of the Companies Act provides punishment for fraud. But now this 448, it says, save as otherwise provided in this act, if in any return, report, certificate, financial statement, prospectus, statement, or other document required by, or for the purpose of any of the provisions of this act, or the rules made thereunder, any person makes a statement. Now, I am referring to this provision to say that the legislature may exclude or include. So if this could be, if fraud is to be avoided, then this provision could make an absolute liability or a strict liability rule, but it doesn't. So it says if he makes a statement which is false in any material particulars, now it says knowing it to be false or which omits any material fact. Again, this could be absolute, but it says no, knowing it to be material, he shall be liable under section 447. So this is the interpretation. Whenever we are referring to any socio-economic enactment, we'll have to see the language, object, and the whether the object can be implemented by including or excluding mens rea. And another, the fourth test, besides these three things, the fourth test was what Justice K. Subbarao referred in his minority, and that was the Judicial Committee Privy Council decision. That was what the respondent, whether he can do something which will implement the object of the enactment. So that will be also one of the tests, whether compliance from the person concerned will further its enactment, further the object of the enactment. So far as this Foreign Exchange Regulation Act is concerned, the majority view is that compliance by the person will forward the object of the enactment, will enable in its implementation. And if we say mens rea, if we don't exclude mens rea, then the object may be defeated. So, Mr. Saurabh, I think I have taken sufficient time, but to the students, I'll say the students from the same Gurukul, I wanted to look, they will find, as I said in the beginning, my knowledge of law will be limited, and law is a very wide field. Even sometimes I may also commit in mistakes in defining or stating the correct position of law. But what I wanted to say that these legal principles can be ascertained. So I'm not referring any further to any further discussion. I'll say what if they want to ask some question or some interaction.
Yeah. Thank you, Lordship. Thank you, Lordship.
But I want to, before I
Sir.
And before ending this statement, I'll say one more thing, that I am very thankful to Dr. Mahavir, Dr. Kiran Gupta, and Mr. Saurabh, to all of you, to give me this unique opportunity. It is a very rare privilege which I am enjoying. I feel a connect to the students of law. I feel a connect to the professors of Law Center. And I am reminded of my old days of the university. And I feel a connect to the students of law because I am still continuing to be a student of law who is trying to learn it every day from the lawyers or from all with whom I am interacting. And so today I have learned from Mr. Jatin and Professor Ramnivas and all of you. So I'll hand over to you.
Thank you, Lordship. It was a privilege to have your Lordship here with us today.
So you can address me as sir, that's fine.
Sir. Right, sir. Right, sir. We are humbled by your presence, sir. In my view, interactive teaching is the best way of teaching.
Yes.
Yes, sir. And by starting with the 3 small stories, you have brought all the attention on the discourse, I'm sure. Sir, you very well said that the purpose of legal education is not to create knowledge of law primarily. It is primarily to acquire eagerness to know law. That was very well said, sir. Your Lordship, and I'm sure, sir, that you have ignited the eagerness of students of Law Center too. Sir, you have touched upon MS George case in a totally new way, in a tabular form, so to say, and that's volumes about your lordship's meticulous approach in whatever you focus upon. Sir, I believe that many of us who are teaching law, especially criminal law, here in Law Center 2 and in other centers also in the faculty, they follow you. They will definitely follow your method. Sir, now the students are most welcome to ask a few questions if they want to.
Sir, I want to ask a question, sir.
Yes, yes. Please, Imani, please.
Sir, here in the M.H. George case, the person had the knowledge of him carrying the gold. But if there is a case where somebody is not having the knowledge that he's carrying it, as somebody else might have put it to escape his own liability. So what would be the case?
So both minority as well as majority, you might have seen they have referred to two instances. They have referred to one instance where somebody put something into the pocket of the person without his knowledge. And another instance where a plane which is not scheduled to land in India makes an emergency landing in India, and then such kind of search is made. So the minority view as well as majority view, they say it will be voluntary bringing into India that will be within the ambit of the act, which will be the subject matter of the offense. So if it is involuntary, say not a conscious act, not a voluntary act, then this offense will not be committed. So this defense is recognized by both majority as well as minority view. Of course, the minority view takes it in the premise of presuming mens rea and excluding the applicability of the offense, while the majority view takes this defense in the premise that mens rea is excluded and I'm sorry, they took it in the premise that mens rea is excluded and the person will be liable. Yes.
Good evening, Honorable Sir.
Yes, sir.
The question is, referring to examples from criminal and or civil law, how the court and the court of appeal can the judges to be able to do so?
No, you will have to repeat the question because there was some, I could not hear it completely.
Anupam, yes, sir. Sir, Anupam, your voice was breaking. You please repeat your question.
Referring to examples from criminal or civil law, how judges in the Supreme Court and the Court of Appeal can avoid following precedent and discuss the necessity for the judges to be able to do so?
No, again, just repeat the last part which you said. The quoting civil and criminal, that I've understood.
Yes, sir. Then how judges in the Supreme Court can avoid following precedent and discuss the necessity for the judges to be able to do so?
Sir, he is basically asking about the precedential value of the Supreme Court judgments.
Yes, sir.
I'll say it's a difficult question because I will interpret in the context of doctrine of judicial precedent, stare decisis. Now, look, the system which we follow, I think this subject must have been covered under the subject of jurisprudence, or it is not yet covered?
Yes, sir, it is there.
So, no, they must have studied under that heading, under that, or they are.
No, sir. Sir, most of them are from first year, so they.
Okay. So I'll say that we are following the system in which judgment of a larger bench is binding on the bench of lesser strength, and a judgment given by a bench of equal strength is also binding on the bench of that strength. And if a bench of equal strength wants to differ, then it will have to make a reference for a decision by a larger bench. I'll say if the judgment is by single judge bench, it will be now also, of course, it is also in Supreme Court now, but it used to be in High Court earlier. So if a single judge has given a judgment and the subsequently some judge wants to differ from it, then he is required to make a reference to division bench. So he has to follow the judgment given by a single judge until that judgment is overruled by a division bench. So this is principle one. Then Supreme Court, the judgments of larger bench will be binding on a bench. And if raises doubt about a judgment of larger bench, then it has again to make a reference to a larger bench. This
Sorry, sir, can I ask?
but just a minute. But Supreme Court is, while other courts are bound by the judgments of the Supreme Court is not bound by its own judgment and it can change its view. But this change will be by a bench of higher strength, larger strength. Suppose you must have read Keshwanand Bharti. So it is 13 judges bench judgment. If tomorrow it is to be reconsidered, then it will have to be 15 judges bench. Right? I think that answers your question, or you intended something else. So another is that suppose the developments in the area will always be taken into consideration by the Supreme Court. Now, if you have a mobile phone, you cannot go by the same view which prevailed regarding those landline phones, different devices, different instruments, different facilities. So you will make a change in law also in view of the mobile phones. That will be the law is also a living organism, that I can say.
Yeah,
Thank you, sir.
I just want to add a line to it, that Supreme Court has a special power under Article 142 of the Constitution, that for the purpose of doing complete justice, taking into consideration the socio-cultural requirement or socio-legal requirement, they can deviate from the precedent for the purpose of doing complete justice.
Yes, that's right.
Saurabh sir, can I ask a question?
Yes, Belu, please.
Good evening, Your Lordship. Myself, Dr. Belu Gupta Arora, sir. I am myself teaching this case to first-year students as a criminal law teacher. So the thing which troubles me, sir, that even I go by minority judgment. That appeals to me more. So how do I justify to the students that what majority is saying is appropriate rather than what I find convincing is the minority part, because it seems to be more pro-justice oriented?
Yes. Now,
what are your comments on that, sir?
No, I'll say the Justice K. Subbarao is impressed by the word luckless victim.
Yes, sir. Yes, sir.
So this is the main ideology or the principle which he is following. Unless a person knows the law, he cannot comply with it. This is the argument basically. But now the question is that my majority view says, now Justice K. Subbarao said that this is not published properly because there is no statutory provision. So it was published, but RBI was not bound to publish in that manner. It could keep it in its files somewhere, and therefore the person could not know. But the majority puts a very relevant question. When you make the law, how do you make people aware about it?
Yes, sir.
You cannot convey to every individual what the law is.
Yes, sir.
Therefore, you will publish it in some usual manner. So that we do in official Gazette of India. In this case also it is published in Gazette of India. Now the second question is where it will be published.
Yes, sir.
The person who is coming to India, he will be from a different country. So are you required to publish your law in that country? Suppose somebody comes from, he was from Germany.
Yes, sir.
So you're required to publish it in Germany. So this, now if you are required to do it in our world, if you feel this requirement is there. And now, while Justice K. Subbarao considers the question of personal liberty, that no person should be punished unless he has a guilty mind.
Yes, sir.
The majority view takes the social interest of the society, economy, national economy. So that is why they say we are dealing with gold smuggling and preservation of foreign exchange. So this is, they say we are looking it from the point of view
Yes, sir.
But madam, one thing which I said, that we are saying, look, law should protect the innocent.
Yes, true, sir. True, sir.
But in this case, one important aspect is he innocent victim, luckless victim?
Thank you so much, sir. Thank you so
So
much.
he is not a luckless victim. His background is he's a smuggler, and
that is the most important point.
And his conduct is that he is carrying gold in a jacket by hiding in crafted pockets. So these two facts drive out his innocence. So it is a matter of chance. He did not get out of the aircraft. The custom authorities had the secret information. So they went to the aircraft and took him out. The question will be that if a person says, I did not go out of the aircraft, but other passengers from that aircraft went out, the question will be, he could also give there could be a possibility of this person handing over any gold to any other passenger in a clandestine manner.
Very
this
true,
you have to.
Thank you so much, sir. And sir, you are trying to stress upon
Thank
the
you,
point
sir.
that his conduct itself is indicting him. His conduct itself.
Yes, Belu. It was the substantial point. His past experience.
Yes, sir. Yes.
Thank you so much, sir.
Thank you, sir. Now I think. Prashasti, just a short question. Very short question. Yes, please.
It's a short question. Sir, in strict liability offences, where mens rea is not generally applicable and on the discretion of judges, whether the motive and intention of accused can be taken into consideration for the degree of punishment which will be given to him?
In this case also it has been taken. The maximum punishment was 2 years, and it is here that has been imposed. So this will be, of course, there has to be sentencing, has to be balancing. And when you have raised the concept of this sentencing, Mr. Saurabh, can I take 1 or 2 minutes more on this?
Yes, sir. Yes, why not, sir? Sure, sir. Sure.
Yes,
please.
So sentencing, I'll say 2 things. Why a person commits crime? So mainly, I'm simply saying need, greed, or lust will be the cause of crime, which will also be learned by social association and will also be the product of socio-economic circumstances of the individual. Now, how many things we have considered? Greed, need, lust, which is his background, and his social association. 5 things we have considered. Now, the punishment. 5 of punishment have prevailed at different times. 1, first of all, retribution, eye for an eye. Then incapacitation, lock him in the jail and throw the key in the sea. Then prevention, if you put him in the jail, he is not going to commit any further crime. But these 3 have now given rise to rehabilitation and this reformation. So first the reformation and the rehabilitation. They say, don't hate the criminal, just hate the crime. Because criminal was a victim of his circumstances. So change his circumstances, he will reform, and he will be a useful member of the society. So this balancing in sentencing is a part of a judicial discretion which we try to achieve.
Thank you, sir.
Sir, if I may ask a question.
Even the last.
Hello, sir.
Please question. Now this would be the last question and a very short question.
Even I want to ask. Okay, sir. Okay.
चलिए छोटा पूछिए, चलिए बताइए. Short question.
Sir, if we make mens rea to be excluded from the statutes of strict liability, then it might be concluded that legislation has the power to convert any act to an offense. So won't it be a license to arbitrary power of the legislation?
Okay, but tell me, how do we constitute the legislature?
So,
how the legislature makes the law? It is a long process. It will be voted, then it will be signed, then it will be notified, it will come into implementation. So if the legislature, I don't think when we say Article 21 is one such provision, which we say just, reasonable and fair procedure provided by law. So these things, and then Article 14, equality, equality before law and equal protection of laws, no discrimination. And likewise, there are many fundamental rights are itself a limitation. So legislature cannot make an arbitrary, whimsical, or some malified law. It will be, of course, the court cannot go into the question of policy of the law, yet it can see the just, reasonable, and fairness of the procedure.
Thank you, sir.
That answers your question, or you have something in mind, something else in mind?
Sir, I have in mind the current scenario. Sir, actually, we all know that the many legislatures of our country just make, when they get the majority, they just try to make some whimsical legislations which are not in accordance with our constitution. Then, sir, the provision of strict liability would make them any act.
No. You have to look. When it is a democratic country, democratic legislature, you will presume that it will make a law in the interest of the society for the welfare of the people. And now look, there are debates now regarding some legislations, but I will put only 3 things. Number 1, Parliament has passed it in accordance with the procedure prescribed by the Constitution. This is 1. Second, it also provides the remedy. If suppose the law is unconstitutional, remedy is there, Supreme Court. It can go into the question of its constitutionality. Now the third question, the policy. The party in power is required has the privilege of implementing its policy. If Congress is in power, it will implement its policy. If BJP is in power, it will implement in its policy. Now the question whether the politicians, why do they have their own ideas and implement them? So when we the people of India elect them, so we empower them to implement their ideas. Now, whether law is good or bad, there will always be a debate. But in our system, we have the legitimate methods of correcting the law.
Yeah, I want to add one thing. Dipendra, you said if the law is against the constitution, then its constitutional validity can be challenged. Judicial review can be held on the basis of constitutional validity of the statute. So law being unconstitutional is different from law whether we like it or not like it.
Okay,
Sir, one question.
Yes, please.
Sir, if the background of the...
all this. Saurav?
Avantika, this must be the last question from the student. Okay.
Okay, sir. Sir, if the background... Sir, if the background of the question was different, that he was not a person, the MS George was not a smuggler, or he has told that he has gold. So would we abide by the minority judgment or not in that scenario? Or in that case also the majority judgment will prevail?
No, you are saying if he had said that he has gold and
he is not the background was also not like he's a smuggler or something. It's an innocent person.
Yes. Even then he was required to declare it in that transit manifest.
But he was not coming to India, like he was by default came to India.
No, it was not by default. His flight was to land in India. Yeah.
And we say he was carrying that gold for Manila. This is what we are told. But look how the question is, if you include this mens rea, then whether you can implement the object. Suppose in this session itself, it was said that suppose I say I did not know that striking a blow with sword on the neck of a person will constitute the offense of murder, and it will be as murder. So if I knew it, then I would not have given a blow with sword on the neck. So does it give me a defense?
No, sir.
And I am saying you will know any offenses. Suppose a person is carrying, I'll put it so in this manner. Alprazolam is a narcotics, is a psychotropic substance, and its possession is an offense. It is a medicine for treatment of some sleep disorders. So if a person carries alprazolam and he says, suppose he has 100 tablets and he says, I did not know that it is a psychotropic substance and I was carrying it for treatment of my sleep disorder. So will you exempt?
No, sir,
Now
in that case.
so this will be because everybody can avoid the application of law by creating these kind of defenses, and you cannot. Knowledge is a psychological some state of mind which you cannot discover. Like how say Justice Subbarao said that it could not apply to this respondent unless he knew about it. Now tell me, how will you ensure that he knew about it? So when a person is boarding a flight and coming to India, you will inform him at that time that this permission is required. Will that be the requirement?
No, sir, he should know prior.
So if he was to know prior, before we knew that he was coming to India, how will we inform him? He was in Germany. So he came to India. Suppose we don't inform him, we are not to inform him when he was boarding for flight, which is to come to India. And we are not to inform him prior thereto. Prior thereto, we don't know who is going to come to India from Germany. So we are not required to inform anybody in Germany, are we? So if you see the judgment of minority, you see the minority view from the view of the implementation of what it is saying. How will you prove that he knew about the law?
Thank you, sir. Thank you.
Thank you, sir.
I think that thanking my dear students also would not be out of place here. They have shown patience, they have shown interest in the subject today, and their experience enriched the atmosphere of this faculty. On behalf of Law Center 2, Your Lordship, I thank you. I sincerely thank Your Lordship for sparing your valuable time and sharing your views on this topic today. Now, I would call upon Professor Dr. Kiran Gupta ji, Director, Seminar Committee, Law Center 2, Faculty of Law, University of Delhi, to present vote of thanks and to formally conclude this seminar. Professor Dr. Kiran Gupta ji.
Thank you, Saurabh. A very good evening to all present in the webinar. Our most valued invited guests, it is my proud privilege to have been asked to propose a vote of thanks on this occasion, on the conclusion of this webinar. I, on behalf of Law Center 2, Faculty of Law, and on my own behalf as Director of the Seminar Committee, extend a very hearty vote of thanks to all of our guests for accepting our invitation. Despite their busy schedule, they have found time to grace this webinar. My heart goes out to thank our respected chief guest, Arun Kumar Tyagi ji. I can't call him justice or judge. The reason is
we are the class fellows.
We are the class fellows. I know him for the last 41 years. Let me tell you, he is an alumni of Law Center 2 because he took admission in Law Center 2. He completed first year of LLB in Law Center 2. Then he migrated to Campus Law Center, and we were the student of Campus Law Center. So we have completed our LLB from Campus Law Center. And from the very beginning, I found him very humble, very honest, very ground to the earth, intellectual. From the day one we talk to him, we come to know that he will be something someday. You, just by talking to him for 5 minutes, you can assess his intelligence. And fortunately, he has proved his intelligence. He is a judge of the High Court of Punjab and Haryana, and a very honest and a good judge. We are really thankful to you. From the core of my heart, I would like to thank you, Arunji, especially for the purpose of inspiring our students to follow the moral values by telling them the stories. You know, if you listen to the story, you remember it. If you listen something in the class, you may forget it. So by telling the stories, you have inspired our students to follow the moral values. And your thought-provoking discourse on the subject, all the participants will remember forever. So once again, I will like to thank you for your sparing your time and for your such a wonderful discourse on the subject. Professor R.N. Sharma ji, we would like to express our special thanks, gratitude to you for sparing your time and giving such a thoughtful discourse on the subject. You have made the webinar very delightful and thoroughly educational. All our students are enriched by your discourse today. Thank you very much. To our young colleague, Jatin Kelo, special thanks are due. He is just a child, has just entered the academy. He is doing research, PhD from the Faculty of Law, University of Delhi, and is also teaching with us. And the presentation he has made today, the way he has explained the facts of the case, the issues involved, the minority and the majority judgment, the difference and all that, and the way he started with the history of the socio-economic offenses and the meaning of the different meaning given by different scholars to socio-economic offenses, and then ending it with the present position and whatever was held in between, that Santanam committee was appointed, and the ways to eradicate the socio-economic offenses. We are highly thankful for his presentation, and I, from the core of my heart, wish him a very good success in life. Special thanks are due to Saurabh Rana for making this webinar a success.
Thank you, madam.
To Belu Gupta, Ajay Sonawal, and the whole organizing team. So many people are involved in organizing this seminar. My special thanks are also due to Priyanka, who has recited the Saraswati Vandana, and lots of thanks to the students who have participated, have understood the discourses made by our guest, and they have shown it by raising such important questions. Once again, thanks to all, and I will be failing in my duty if I won't thank our professor in charge, who is the guiding force behind us. Whenever we want to do something in this committee, he always encourages. So thanks, Professor Mahavir Singh ji. Thank you very much. Once again, thanks to all for making the webinar a success and educational endeavor. Thanks to all of you.
Thanks a lot.
Thank you, ma'am. Thank you.
Professor Gupta, Professor
Yes.
Kiran Gupta, I think
Yes.
you accidentally missed the name of Professor Ramnivas Sharma. You please extend thanks to him also.
No, I have not missed his name.
Okay, I'm so
R.N.
sorry because my
Sharma.
connection was erratic. It was unpredictable.
No.
I thought I must remind you about it.
No. I thanked him.
Thank you so
I
much.
forget
Thank
to
you.
name
Thank you
you.
so much.
I forget to name you.
It's all right. I I did not want to be
You
mentioned
are
here,
part
ma'am.
of the organizing committee.
No,
You are
no,
part
I
of
did
the
not really
organizing-
want to be mentioned. I really did not want to be mentioned at all.
Okay,
Thank you all. Thank you, madam. Thank you,
Thank
sir.
you.
Thank you, Justice Arun Kumar
Fine.
Tyagi, sir. Thank you. Thank you,
Thank you,
everyone.
sir. Thank you.
Thank you.
Thank you.
Thank you, Professor Saab. Thank you, Jatin. Thank you. Bye bye.
Thank you, sir.
Thank you.
Thank you, everyone.